Indian Contract Act 1872. Preamble. Whereas it is expedient to define and amend certain parts of the law relating to contracts, it is hereby enacted as follows. Section 1. Short title. This act may be called the Indian Contract Act 1872. Extent and commencement. It extends to the whole of India, saving nothing herein contained shall affect the provision of any statute, act or regulation, not hereby expressly repealed, nor any usage or custom of trade, nor any incident of any contract, not inconsistent with the provision of this code. Section 2. Interpretation clause. In this act, the following words and expressions are used in the following senses, unless a contrary intention appears from the context. 2a. When one person signifies to another his willingness to do or to abstain from doing anything, with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. 2b. When one person to whom proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. 2c. The person making the proposal is called the promiser, and the person accepting the proposal is called the promisee. 2d. When, at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. 2e. Every promise and every set of promises forming the consideration for each other is an agreement. 2f. Promises which form the consideration or part of the consideration for each other are called reciprocal promises. 2g. An agreement not enforceable by law is said to be void. 2h. An agreement enforceable by law is a contract. 2i. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. 2j. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Section 3. Chapter 1 of the Communication, Acceptance and Revocation of Proposal. Section 3. Communication, Acceptance and Revocation of Proposal. The communication of proposal, the acceptance of proposal, and the revocation of proposal and acceptance respectively are deemed to be made by any act or omission of the party proposing, accepting or revoking, by which he intends to communicate such proposal, acceptance or revocation, or which has the effect of communicating it. Section 4. Communication when complete. The communication of a proposal is complete when it becomes to the knowledge of the person to whom it is made. The communication of an acceptance is complete as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor, and as against the acceptor when it comes to the knowledge of the proposer. The communication of a revocation is complete as against the person who revokes it when it is put into a course of transmission to the person to whom it is made so as to be out of the power of the person who makes it, and as against the person to whom it is made when it comes to his knowledge. Illustration. A proposes by letter to sell his house to B at a certain price. The communication of the proposal is complete when B receives the letter. B accepts A's proposal by letter sent by post. The communication of the acceptance is complete as against A when the letter is posted, as against B when the letter is received by A. Illustration C. A revokes his proposal by telegram. The revocation is complete as against A when the telegram is dispatched, as it is complete as against B when B receives it. B revokes his acceptance by telegram. B's revocation is complete as against B when the telegram is dispatched and as against A when it reaches him. Section 5. Revocation of proposal and acceptance. A proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer but not afterwards. An acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor but not afterwards. Illustration. A proposes by a letter sent by post to sell his house to B. B accepts the proposal by a letter sent by post. A may revoke his proposal at any time before or at the moment when B posts his letter of acceptance but not afterwards. B may revoke his acceptance at any time before or at the moment when the letter communicating it reaches A but not afterwards. Section 6. Revocations how made. A proposal is revoked, number 1, by the communication of notice of revocation by the proposer to the other party. Number 2, by the lapse of the time prescribed in such proposal for its acceptance, or if no time is so prescribed, by the lapse of a reasonable time without communication of acceptance. Number 3, by the failure of the acceptor to fulfill a condition precedent to acceptance, or 4, by the death or insanity of the proposer if the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. Section 7. Acceptance must be absolute. In order to convert a proposal into a promise, the acceptance must, number 1, be absolute and unqualified. Number 2, be expressed in some usual and reasonable manner unless proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it is to be accepted and the acceptance is not made in such manner, the proposer may, within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accepts the acceptance. Section 8. Acceptance by performing conditions or receiving considerations. Performance of the condition of a proposal or the acceptance of any consideration for a reciprocal promise which may be offered a proposal is an acceptance of the proposal. Section 9. Promises, express and implied. Insofar as the proposal or acceptance of any promise is made in words, the promise is said to be express. Insofar as such proposal or acceptance is made otherwise than in words, the promise is said to be implied.